Hello, welcome to another edition of The Naked Truth. My name is John Singletary.
And my name is Ramon Roan.
Tonight, we're going to talk about untruthful judges on the bench. It's unfortunate that we have witnessed when judges tend to say, it appears that, what it really appears is that they're about to tell a lie. And that's just as simple as it gets. Unfortunately, on several occasions, we've witnessed where, for instance, in the order made by Judge Scarborough, Charleston, South Carolina, dealing with a Wells Fargo foreclosure, where Judge Scarborough said, it appears that the appellate procedure no longer exists for John Singletary dealing with Wells Fargo, when all it took was a simple calculation of how long from the order to the time lapse for appeal, and he would have known, and he did know, that the appeal was still in process at the appellate court, that there was an order from the appellate court, a mandate of state issued telling him and the state court not to proceed, and he writes that it appears that the appellate remedies have been exhausted, when he knew that that was not the truth. Another instance where Judge Scarborough, said that it appears that, let me not say Judge Scarborough in that situation, he was the judge dealing with the Wells Fargo case. But the judge said that was for the order taking the case from the circuit court and ordering it over to the Master and Equity Court, which was his court. The order said, it appears that no one requested a jury trial. When not only does the cover sheet say that a demand for a jury trial was requested, but there were several other documents that stated that a jury trial was requested. I stated before him that a jury trial was demanded, and he simply ignored it, understanding that it was a violation of due process and equal protection of the law. It said, it appears that no one requested a jury trial, when the jury trial demand not only was on the cover letter, but it also was on a motion requesting the jury trial in big bold letters that was submitted to him a week prior to him moving forward. And so when the judge says it appears, all we're saying is that you want to look out, you want to be careful, because it appears based on the orders and the rulings that some untruths are about to come your way.
John, are you saying that a judge in these United States would lie? You can't be saying a white man, because you know 90% of them are white. White man lying?
I can say,
John, white people, let me tell you, John, I'm sorry, but John, white people don't lie. They don't.
they stretch the truth.
Man.
I can say that in this situation, absolutely, that to say that it appears that remedies were exhausted, to say that it appears that no jury trial was demanded, that was a flat untruth, a lie, stretching of the truth, incorrectness, whatever you want to call it. Whatever you want to call it, it violated due process, and it was calculated so that there would not be a remedy for the plaintiff in the case, and in order to give the defendant a financial gain that would not have been there before.
But it goes to a problem with in our justice system, that there's lack of African black representation on the bench.
Right, but I mean, he's not the only one. There's several others that have.
Oh, no doubt. But but how many? But 90% of those judges are white.
Of course.
And white people just don't lie, John. I hate to tell you that, man. Kunta Kinte. They don't lie, man.
In that same case, we had where Judge Scarborough, he recused himself.
Mm-hmm.
And after recusing himself, went back on the same case. Judge Nicholson, he came and said that Judge Scarborough, when he said that he recused himself, he wasn't recusing himself from the case. He was just recusing himself from hearing any more substantive issues from me. Well, recusal has nothing to do with any motion or issue that I may put before a judge, but recusal has to do with whether or not the judge felt that he could be on the case,
right,
and issue impartial judgment. And when he recused himself, he's saying, I can't be impartial in this case, that I'm going to end up taking sides, that impropriety can't be given here because I'm going to show favoritism. So that's what a recusal has to do with. It doesn't have anything to do with my motions that come before the judge. And so for Judge Nicholson to say that, either he doesn't understand what recusal means, or the judge never recused himself, which the court record bears out that he does.
Yeah. It's a shame that you're not only as an African. Well, first of all, do you think the reason why you catch this kind of hell because you're black?
No.
Wait a minute. Okay. Oh, all right. Okay.
I know it's why.
You know it's why.
Yeah, I know it's why. Right. And unfortunately, Judge Nicholson's a Citadel graduate, my old alma mater, which the honor court system says that, or the honor code for the Citadel says that a cadet does not lie, cheat, steal, or tolerate those who do. And somebody's not following.
Somebody's not following.
Somebody's not following.
Somebody's not following.
But on a bigger note, untruthfulness of judges on the bench. Yeah, oftentimes a judge can take the facts of the case and manipulate them to arrive at what he wants as the end result in the case. And oftentimes, particularly when it comes to summary judgment, they will manipulate the facts so that a summary judgment they issue, oftentimes even when it does not satisfy the requirements for summary judgment. And so we have to take a look at the fact that, there are untruthful judges on the bench, and when it happens, then we have to rebut it. We have to say something. We have to stand up for our rights. Because if we don't, they continually do it, sweep it under the rug, and nothing's ever said except a sad story. But that's why we have YouTube. We have YouTube to tell it over and over and over, expose it for as long as we shall live.
We have to have more blacks on the bench. We need to have more blacks in our police officers.
Sure.
We need to have more blacks as prosecutors and district attorneys. We need to have more blacks in our justice system that are rendering this justice. Otherwise, what John is getting, what I'm getting, is you're getting white justice. And white justice doesn't mean that it's right. It means that you're not gonna receive your justice, because that's the kind of justice you're gonna get. You're gonna get that justice. Whoever's sitting on that bench, that's the kind of justice that you're gonna get. And that person is white person. And
as I was saying with Judge Nicholson, that he tried to give the opinion that a recusal is not a recusal. And to my understanding, a recusal is a recusal is a recusal. Now, we're not saying that we want black justice. We want neither white justice nor black justice. We want constitutional justice. What it says in the Constitution. We understand that there has been traditionally a majority white judges, as well as we understand that they have made in practice the decision through their orders that they simply will not allow African Americans in South Carolina to get the type of justice the Constitution says that they should and guarantees. Instead, what they give is a Judge Taney type justice that says that a black man has no rights that a white man has to respect. The same way there was a moratorium put on hiring teachers who were non-African American for a period of time until they were more representative of the population, the same thing should be done on the bench for judges. There should be a moratorium put on hiring additional white judges until the other populations, Latinos, African Americans, Koreans, Asians, are able to be represented on the bench. The history has proven that they will deny our justice, our due process, and equal protection as if they are Judge Taney himself.
That's right.
And that just simply can't be tolerated. Until we get the bench straightened out, nothing else
Nothing else.
is going to matter.